Lawrence County.
Here we go.
Depends on WDXE News. On the air since 1951. Legend. 105.3, 95.3.
Once again, it is time to visit with Stan Pierchoski, Bulletproof Estate Planning here. And how are you, buddy?
Good morning, Jeff.
Good morning.
I'm well.
Good morning. Good morning. We've made it to Friday again.
We have. And I have to tell you about some news.
Yeah.
Yesterday, 12:30 a.m., just after midnight, became a grandfather for the third time.
Oh.
I told you last Friday my wife was down to me at Miami.
That's right. That's right.
It was actually due, I guess, tomorrow, the 6th. But anyway, got a new granddaughter.
Oh, congratulations.
So yeah.
Congratulations. That's awesome.
They sent me some pretty cool pictures. Mothers and child health is doing well, and yeah. So that was interesting.
What a blessing. Very good.
Yeah.
Very, very
And
good.
she's going to be moving back up here at the end of the month.
Yeah.
Her and her whole family are going to come back up, and they're going to stay permanently.
That is awesome.
She's going to go to law school, and she's going to someday take over for me.
Well, see, there's the plan. That's good.
That's the plan. This is a major milestone in the plan. She was going to move up, and not till after she had the child.
Yeah. Okay.
So,
Well,
yeah.
that's great. That is awesome. That's good
Baby
news.
steps.
All the way around.
Little step to the goal.
And I know you'll be tickled to have them up here close.
Oh yeah.
Yeah, that's awesome.
So yeah, my Miss Tammy's in grandma heaven.
Oh, I'm sure. I'm sure. We had our grandbaby the last few days because Missy was on a trip. He's 3. Will be 3 in August, and we had our hands full.
Oh yeah. The other two are 5 and 3.
Yeah.
and now 0 years old.
There you go. So yeah, they're gonna bring lots of joy to you.
They will. They will. It's fun when they can start communicating with you.
Yes.
When they're real little, they're cute in a way, certain ways, but they start to get actually fun when you can talk to them or something.
Yeah, that's where John Daniel is now. He's beginning to talk really well and says some of the darndest things. That's for sure.
Sometimes they get mad at me. They say, "Well, my grandson's name is Luke, and he'll say something." And I said, "I don't understand what he says." And they said, well, he says this. They get frustrated because I can't understand what it is. You're around them all day long. You can figure it out.
Yeah, once you kind of get used to their language, you can tune in on it.
Yeah,
So.
yeah. But anyway, so that was fun. So yeah, you mentioned a little bit off mic when we first came in about the seminar last week, and we had the seminar at the Star Theater. Had a great crowd, about 75 or more
wow.
people there. Pretty crowded.
Wow.
And they were really one of the most inquisitive bunches I think I've ever dealt with. I would think I was there the longest I've ever been there, answering questions afterward.
Wow.
So,
well, that's great though. I mean, that's what it's all about. That's what you're doing it for.
Exactly. So
yeah,
it was. I think we had. The girls do the list and everything, but I think we may have had quite a few just walk-ins, which is typical. We have some.
Right.
I don't know exactly what it was this time, but I think it was more than usual because I think our RSVP list had something less than what we actually had, and inevitably there's some people that just can't make it at the last minute too. So anyway, it was good. So the seminars are they're that popular now every time.
That's awesome.
Or at least for the last 6 or 8 of them. We do them every other month. The next one we're going to do is out toward the end of July. It'll be our July 250th birthday.
Yeah.
It's July the 25th, a Saturday.
25th.
And it's going to be over here at the WLX radio station.
Yeah, we'll be back here then.
Yeah.
That's great. On the 25th. We need to make note of that.
On WKSR, I do a bonus hour on Thursdays over there. And
yeah.
I always start off with Stan Pierchoski's Oldie of the Week, right? It's sort of been a signature thing we've done for years now.
Yeah.
And I typically pick things from the 60s, so I had to go with welcoming my granddaughter in with the Beatles' birthday.
Oh, that's great.
60s style.
That's great.
Happy birthday. So anyway, yeah, I'm smiling a lot. So
absolutely.
Miss Tammy will be back probably around middle of next week.
Good deal. Good deal.
Yeah, so anyway, it was fun.
Making sure that we're on all the places we're up and good. We're good.
Oh, good. Yeah, I'm going to come over here and talk, and we'll be heard.
That's right. That's right.
So, all right. So let's see. What are we going to talk about today? You got any questions?
Well, I haven't developed any yet, but I will. I usually do. And of course, the phone lines are open for Stan as well. 766-9393 if you'd like to talk with Stan about estate planning. And one of the things that's happened here at the station is we've got a new guy on the Wednesday who does financial planning, and they kind of bleed over on each other a little bit here and there. And so some of that was talked about Wednesday. And he was right. He said, you know, you've got these people that are key people in what you should plan, and your estate planning was one of them. You got financial planners, you got estate planning.
Right, right.
So,
and part of estate planning is financial planning.
yeah, it is.
I mean, most people that do it have to involve their financial person if they have one to some extent. So,
Sure.
So,
Sure. And we were talking about too how that, and you and I have talked about this before too. When we think about doing a trust, in my mind, for many years, trust were for people with a lot of wealth, and that's not necessarily so.
yeah, and don't feel alone in that thought. I mean,
Yes.
I hear that a lot. You know, it's or I get the concept that I heard about trust, but I don't know what it really does.
Yeah.
That sort of thing. But no, you don't have to. As a matter of fact, I like to think of it this way. You know, because when you do a trust, you don't go through probate, and there's a cost to probate.
Yeah.
And so if somebody's estate is relatively on the small side, I mean, it's more so the reason to not have it that all your wealth go where you want it to go. If you have a small amount of wealth, and then it's more important for it to go where it's supposed to go.
Yeah.
So if you have this probate process that's involved, that can consume some of that. And you know, if you have $100 million estate and people fight like cats and dogs, and it costs you $10 million in court costs, you still have $90 million to divide, right?
Right.
But if you're relatively modest estate, you just want to make sure the losses are minimized.
Yes.
You know, on our seminars we talk about our asset protection trust. And it's very popular. We do a lot of them. These seminars usually yield a lot of people that do them. And you know, a couple of things. You know, I was looking at some data, I don't know, maybe a month ago, about how people live longer. Mm-hmm. And I think under the Department of Human Services, they've back in 24, I believe they upped the average lifespan to like 78.3 or something, but for something was less than that. Mm-hmm. And you know, we do a lot of long-term care planning as well, and people are living longer. You know, medical science, but they're not always living longer because they eat better or anything like that. So, if you're going to live longer, that means you may have more years at risk, because just living longer doesn't mean those extra years are healthy years.
Yeah, that's true.
And so, in other words, if something goes wrong and you have to go into long-term care, you may be there a lot more years, just simply because people are living longer these days.
Yeah.
So it's kind of a catch-22 in a way.
Yeah.
The good news is we live longer. The bad news is it may not be that high quality of living.
For some, yeah, that's true.
So
And could be for you too.
well,
anybody.
it's also it's a more of a reason. And what struck me was they said living longer is a likelihood. Okay, so if that's a likelihood, that makes the planning more of a probability. It makes it more of a necessary thing to do.
Absolutely.
If you're going to be living longer. So hopefully we'll all live longer. I don't know. Sometimes I wonder.
Well, we want to do the best we can.
You know, I had somebody whose mom just turned 100 or 101, and
Yeah.
you know, although that's great. I just wonder sometimes, you know, would I want to live to be 100? I imagine when I'm 95, the answer would be yes.
Yeah. You know, I think about some of the old biblical characters who lived hundreds of years.
Oh,
And I just wondered what that was like, because they saw generations and generations. A lot of wisdom passed along.
Yeah, and I guess you don't think much about the end.
No.
I mean, and again, what would you use as a standard?
Yeah. Yeah.
You use the standard is how long everybody else lives, right?
Yeah. Yeah.
And you know, it's a long time to not be taken out by an accident or disease or.
Wow.
So,
Yeah.
yeah.
Well, it's good to plan. That's what this is about.
That's right.
Is trying to make plans for the unknown a little bit.
You know, and the concept of hanging on to your wealth and not losing it to some kind of process, long-term care, probate, or something, is more and more attractive, because, you know, if you're got some kind of 401k or a IRA or tax-deferred fund accounts, I mean, go look at it today and see. I mean, it's growing like gangbusters.
That's true.
I mean, they're going to do that for a couple more years. It's just, you know, it's more and more wealth for you to protect. So,
Yeah.
I mean,
Yep.
these are definitely the golden years, the golden age.
The golden age. That's right. We'll take it. Do the best we can with
The
it.
stock market just goes merrily on.
Yeah, it seems to.
Yeah.
Seems to. Well, Speaking of that, of course, we're not. This is not about investing, but you want to protect those,
Right.
And plan for them. And of course, we've talked about the various options that people have, and of course, the bad option is to do nothing.
Well, it is an option, but it's not always a good one. Well, I mean, there's so many options. There's so many things you can do.
Right.
To do nothing is just you're not availing yourself of some of the very beneficial things that could be done.
Yeah, yeah.
But I get it. It's easy to do nothing.
Yeah.
Status quo is a.
You know, and I think, and Mike, you've talked about this before, but it's especially true with me. Is sometimes I do nothing because I'm not sure what I want to do or how to do it.
Yep. I think that's a real contributor to procrastination.
Yeah, me too.
Because you just don't. I mean, you can almost think of it if you're trying to buy something on Amazon. I don't know. Let's say you're trying to buy I don't know, a new motor, something for the car.
Yeah.
And there's like 15 things to choose from, and this one gets good reviews, this one doesn't get so good reviews, this one gets somewhere in between, or
Sure.
the one that gets just as many good reviews as it gets bad reviews. And you just, it's like, I don't know what to pick.
Yeah.
And you tend to not pick.
Yeah.
And so I think it's the same thing.
It's hard to settle in.
With estate planning, you go online, you look, you call around, there's hardly any attorneys that do it. And, you know, the attorneys that list in their ads that they do 18 things, and one of them is estate planning. I mean, I have found that almost 100% of the time, that means they don't do any one of the 18 things well. They just do a little bit of everything. So,
Yeah.
It's hard to find anybody that will tell you what the options are.
Yeah.
I know some estate planners that say all we do is wills, and that can be it's an area of estate planning, but it's not.
It's not the whole.
It's not the full blown thing. It's just one portion of it.
Yeah.
That's like saying I do criminal work, but I only do DUIs.
Yeah.
You know, so it's hard for people to find the options. That was the whole concept of the birth of my seminars probably 10 years ago.
Yeah.
A lot of people come in and don't even know they have options.
Yeah.
I used to hear people say, I want to do a will, or my wife and I want to do a will, and I would say something like, great, would you like to hear about some other options? And the overwhelming response I would get was, I thought a will was all you could do.
Yeah.
What other options are there? You know, then of course there was the topics of trust.
Right.
And they didn't know. And then they would say something like you said, well, I thought trusts were just for wealthy people.
Sure.
Or I've heard of a trust, but I really don't know what it does.
Yeah.
And so, you know, it doesn't have to be for wealthy people, and it can be for anybody. Big
Sure.
estate, small estate. The big advantage of the trust is you control where it goes, your stuff goes.
Yeah.
Great control.
Well, see, when you think about that, though, Stan, and this is just for conversation's sake, that's what a will does too, doesn't it?
It does, but there's certain things you can't do in a will.
Yeah.
Or can become very cumbersome to do in a will.
Yeah.
So if you're just going to say, my 3 kids each get a third of all my stuff, the language in the trust would be the same as the will.
Yeah.
The difference would be the trust distributes the property right away with no additional costs, where the will has to go through probate. And
Okay.
probate is a court proceeding that is riddled with duties, obligations, deadlines, costs. And you know, the cost of it is kind of all over the board, just depends on the structure of the estate, but for by far it exceeds the cost of a trust. And
Yeah.
so there's that. Then if you want to conditionalize how you leave things, like I say, you got an issue with a child. Let's just take a simple issue like they're a spendthrift, just blow through money like water, right? And you don't want them to. You kind of want to live with inheritance, so you want it to be a good start somewhere. You don't just want to have a big party, jacked up truck, or
Sure.
just spend it on stuff like that. You know,
Sure.
we don't want it to be just a windfall to them, so they just have a good old time. And if you in a will, you can't really conditionalize it. You have to just give it to them. Give it to them; it's outright distribution.
Yeah.
In trust, you can put all kinds of conditions on it. Now, I will say that before somebody calls in and says something, when you can create a trust in a will, it's called a testamentary will.
Okay.
And so there's ways in a will to put conditions on that, but the trust that's created by the will is under the jurisdiction of the probate court. It doesn't become a trust until the will is probated.
Okay.
And the probate court establishes the will, and technically can be over the will over the trust for the life of the trust. Now, in Tennessee law, there's a way to take it out of probate court and just let it, do what the trust's supposed to do and not be there forever. But I like to take the position, if you write a trust that says where everything goes,
Right.
it's probate avoidance. It's not going into court. It doesn't have to. So if we're gonna write a trust, why write one inside an instrument that does have to go through probate? It's just a whole level of extra cumbersomeness to the court process, and whenever you deal in court, the more you do in court, the more it costs. And so you can do that in a will, but I don't even do those in wills.
Yeah.
People write me wills if they want a testamentary trust in there. I kind of say I'm so against it that I'm not going to do it. I don't get too many requests for that, but when we do a trust, the whole trust is outside of probate. So why do a trust instrument that's governed by the probate court, and you have to deal with the probate court on every aspect of it? You're just inviting a whole lot of stuff that doesn't need to be there.
So part of the reasoning and strategy for a trust is to avoid probate.
All trusts avoid probate, and we do a couple of different kinds of trusts, but they all do at death. They avoid probate. That's right.
Okay.
Now, and probate it's all over the board. I mean, it takes a long time for one thing, probate, but the cost can be, I used to do probate. I don't do it anymore, but when I used to do probate, we would see the cost would probably be the lowest when you had like a sole heir. Okay, there was not much, nobody was contesting the will. All the property that was left over in the residual would go to the one person, so there was no complaining about anything. But when you have more than one beneficiary and you have the opportunity of people to be disgruntled or file a challenge or complain about their share, those are the places where it gets very expensive. If you have minor children involved and the court wants to involve like a guardian ad litem or something, that's where it can get a lot more expensive.
Yeah.
So, but I mean, even if it's on the inexpensive side, it's usually more costly than the will.
Okay.
So, it's just less. I mean, the statistics I see, it's anywhere from 5 to 10% of the estate. Now, that's a big range. So, but on the low side, it's still relatively expensive.
It's interesting.
And not to mention, just the hassle factor. I mean, it's a tremendous pain.
Yeah.
I get people all the time that are dealing with their parents' estate or something. And I think I talked to somebody just last week that said, they're like 3.5 years so far. And they said it just seems to just sit there and do nothing. They call and said, well, we're waiting on this, we're waiting on that. And it just kind of drags on and drags on.
Yeah.
And
We
so-
had we handled the selling of part of an estate a while back. It was being handled by a nephew of an uncle that had passed, and the nephew had been dealing with this estate for quite some time, and you could tell that he was very tired of having to deal with it. It was so much to do, and so we liquidated our part of doing what we did. But it was just interesting, and I see that a lot, that people are kind of wearied and worn out with having to do all the things they have to do with this.
And I'm sure before you guys could liquidate that property for them, you had to have an order or permission of the court to do so.
Yeah, you have to have a letter of testamentary, you have to have all that stuff, and they have to go through all the probate deal and all kinds of thing. And we can sell property before the probate is ended, but they still have to go through that first.
That's right. That's right. I mean, you sell the property certainly before the probate ends, because now somewhere toward the end of probate you reach the distribution phase where you distribute the property.
Right.
And so if
it has to be liquidated.
If the call is made to sell the house, then you have to do sell it and then distribute the proceeds.
Right.
But the house is just one aspect of the estate. What about the house that's full of stuff?
Yeah, all that stuff too.
All your stuff.
Yeah.
Sometimes that goes too, but with the auction. But still, I mean, and what about stuff? Like my house is polluted with stuff. I mean, in every nook
That's
and
not
cranny.
a good way to put that.
Well, every nook and cranny there's something, right? Stuff that only has value to me.
Yes.
And so you have you auction off the house. You got all this stuff. You maybe have a yard sale for all this stuff.
Yeah.
What about all the stuff that you can't use 100% of the time that you can't even give away?
Yeah.
Okay, so it's like, okay, you have a yard sale. There's some things that nobody's gonna take.
Right.
So then you have, okay, so I guess we take it to Goodwill or something, or take it to God's storehouse, or donate it somewhere. And then maybe there's some stuff that they won't even take, because there are. And then, so we just have to take it to the dump. I mean, we have to empower these people that are in charge, either the executor of a will or the successor trustee of a trust, to deal with this stuff, because it's got to go somewhere.
Yeah, somebody has to deal with the estate and be in charge of it.
That's right. I mean, so you deal with the real estate part, but there's more property in people's estates. That then there's the money in the bank or investments or some
Yeah.
some posture with a financial institution in some form or another
Yeah.
that has to be dealt with. Then you got to deal with those people.
Yeah.
And they won't even talk to you unless you have some sort of authority that you can talk to them. Either,
Right.
during life it's a power of attorney. After death it would be, sworn in as the executor with the letters testamentary, or show that you're the successor trustee of the trust. They won't even discuss it.
So if you've got it set up right and your possessions are in a trust, then you avoid the probate and it immediately follows your instructions. But what about bank accounts and things like that? You said something about, do you have to share the entire trust with the bank, or?
No, not really. I don't see why. If the bank asks for it, they don't really want it. They just think they need it.
But you saw there's some kind of document though that you were telling me about that I'm trying to remember.
Okay. I hate to withhold that honorary degree of yours.
Yes, I'm trying to remember the degree here.
Well, let me go over that because it's a good point.
Yeah.
It also is a good example of how things go swiftly outside of probate.
Yeah.
So, let's say, let's just use myself for example. If something happens to me, I pass away.
Yeah.
Let's say I name my oldest son as my successor trustee.
Yes.
All right, now, and I got a bank account. Let's make it simple. I just got a bank account. I got 3 children, so let's say $150,000 in the bank. Nice number, divisible by 3, right?
Yeah.
My son can literally walk into the bank and say, I want to assume control of my dad's bank account.
Yeah.
Now the bank won't say something like, under what authority are you claiming to take over your dad's bank account?
Right.
They're not going to just let you do whatever you want.
Right.
And he's going to show them documentation, it's called a certificate of trust, that shows that he's the successor trustee. He's also going to show them death certificate showing I'm not around anymore. And the bank will recognize that immediately. That's, and now, and the reason a bank will recognize that immediately is because just about all banks have a trust department. I mean, they're no strangers to trust law. They know how it works.
Right.
And so they don't need to see the trust because it doesn't matter to them what your distribution is. I could be giving it all to a charity, but still the successor trustee has to gain control of it to do what the trust says to do.
Right.
So they understand that. And literally they would say, okay, what do you want to do with this bank account? And if he says something like, well, how much is in there? And they said, it's $150,000, exactly. Well, I want to write 3 checks. One for $50,000 to myself, one for $50,000 to my sister, and one of $50,000 to my other brother.
Yeah.
And then I'm going to close the account. I want to exhaust the money in there and close the account. And it might take him 30 minutes, but he'll walk out of the bank and have those 3 checks, and he'll go hand them to his brother and his sister, and that asset will have been distributed just like that.
Yeah.
Now, compared to probate court, you have to, notice the court that that's what you're going to do. You've got to give all your opponents 30 days or something to object if there's any. Even if you don't have any, you got to put out the time period for any objections, and then the court has to give you permission to go do it, and then you go do it.
Yeah.
So
And that's so good. And what was the letter thing? The
certificate of trust.
certificate of trust. I knew there was some, that'll be on the test, I bet.
Well, every trust has a certificate of trust.
Yeah.
And here's a good example of what the certificate is. It lets people know, it establishes that you have a trust, and it's proof that you have a trust.
Okay.
And because when you start a trust, when you make a trust, and you want to put property into it, let's go back to the beginning where you draft the trust. Now you say, you know what, it's a revocable living trust, so I want to go put my checking account, my savings account into the trust. You go to the bank and you say, hey, I did one of Mr. Stan's trusts, and I want to put them into my trust.
Yes.
And the bank's going to say, great, we know what to do. We're banks, we have a trust department, we're no strangers to trust law. However, they're going to say, but you have to prove to us that there really is a trust. So that under banking law, it can be a vehicle of abuse if you create an account in the name of a trust if the trust doesn't exist. Why anyone would do that, I'm kind of at a loss, but I get the concept of it.
Yeah.
So the bank's entitled to make you prove it. Now, I always tell my clients, you don't show them this big old document that's the trust. It's a 60-page document, the trust.
Right.
And a lot of times it's just riddled with personal information.
Sure.
In there it says, okay, I've got a drug-addicted child, so I'm giving him this money. I'm going to give it to his sister and let his sister control it, make sure it's never used for a drug addiction problem. But if he ever becomes clean for a period of 3 years, then she bows out and it becomes, personal stuff that's in there.
Right.
And they're not entitled to that. Okay?
Right.
So if they ask for it, you say, no, we're not going to give that to you. Now the legislature solved the problem by creating a certificate of trust. And the the statute for a certificate of trust says, any person or entity that wants to prove the existence thereof, of the trust, can do so by relying on a certificate of trust if it has the name of the trust, the date of the trust, who the original trustors are, who the original trustee is, and who the successors are.
Yeah.
Those 5 things. And if it does, that's all they need. That's all they're required by law to request. Because now they have their proof that the trust exists, but they've been exposed to no personal information.
Right.
And so I always tell people, if you go to the bank and the bank says, or the person you're talking to says, we're going to need a copy of the trust. I said, don't get into an argument, start banging your fist and say, my lawyer said you're not supposed to see. Just get me involved. Just call me and tell me.
Yeah.
And I'll call over there. And I'll call, because I have found that and this doesn't happen very often, but when a bank asks for that, the bottom line is we're talking to the wrong person.
Yeah.
Every time. So I'll call somebody a notch above and say, hey, I'll explain what happened. And you know what they say? Every time. The manager, the person up below, they'll say, I don't want that 60, 70 page document. I want that 2-page certificate of trust. And I'll say, how about going down on the floor and telling those folks that when they come back in, that's what they want. The problem fixed. In 60 seconds, the problem is fixed.
Yeah.
So, don't you start arguing with them at the bank, because you're not going to get anywhere because the person you're talking to doesn't understand.
Yeah, and they think they're doing the right thing.
Now, I like the Bank of Frank Ewing has invited me on 2 occasions to go there and speak to the employees.
Yeah.
Because there was a concern, not a concern, but a lot of folks were saying, why are all these people coming in here and changing their bank account in the name of a trust?
Yeah.
Which were all mine.
Yeah.
Anyway, and so they asked me, and I came, and I sort of gave my seminar, but I kind of had to modify it to be from a banking perspective.
Sure.
Explain to them, when they come in and say, I want to change the name of my trust from Stan and Tammy Pierchoski to Stan and Tammy Pierchoski, trustees of the Pierchoski Living Trust, or something like that, here's why they're doing it.
Yeah.
And here's the authority in which to do it. We talked about the certificate of trust. That's the authority you need that the legislature says is designed to satisfy your need that it exists. Because if you really want to understand how most anything in law works, just follow the liability, right?
Right.
And on a certificate of trust, if the bank needs to make sure a trust exists, and you say, yeah, don't worry, trust me, I did one, that's not enough for them.
No.
Okay? And they want to see the trust, but they're not allowed to see the trust by law, okay? So when the legislature says you can, if you get the certificate, you're good to go. So here, look at it from the bank's perspective. If they have a certificate, has that information in it, signed, and some dignity, either notarized or witnessed, okay? Now they can say, okay, we'll do it. Now, what has happened is, if somebody's trying to hoodoo the bank and open up an account and there really is no trust, and they use that forged certificate or something, the bank is held harmless because say, hey, statute says I can rely on this certificate of trust.
Right.
You have one, I'm relying on it. So if something happens, we have no liability because we have done everything we're supposed to do.
Right.
If you have hoodooed us with a false certificate of trust, our job is not to police that.
Right.
And so if there's any liability at all to the bank, that protects them.
Yeah.
So, and that's why it exists. It's because the trust. The bank is concerned sometimes, okay, if we do this, there's just some clause in this trust somewhere that says, you can make us a creditor or something. Sometimes banking law, I think, is a little bit over the top, but it's not I'm out of my lane in banking law, but anyway. But it doesn't happen very often.
Yeah.
And I think all the banks around here, for several counties, have seen what we do.
Sure.
And, they hardly ever push back because we do what we're supposed to do.
Yeah.
And they end up with their certificate of trust. And then that certificate of trust serves a few other purposes. Like I've had many requests from your field, the real estate business, when at the administration of a trust and getting, distributing property or something or selling it, the title insurance company, something like that. Sometimes they want a trust and they'll ask me to amend the trust to show that it shows who the trustees are. And let's say one of them has passed away. They would like an amended certificate of trust to show that the wife is now the sole.
Yeah.
Because of husband's death, the wife now became the successor trustee by operation of the trust. And it's just updated to show who the person that has the authority to deal with the real estate is.
Sure.
Because one of them is deceased, and that's okay. We're glad to update those to reflect that.
Yeah.
By death or by incapacity or whatever the person's been removed.
Very interesting.
So it's there's a lot of statutory not regulation, but the statutory authority that governs how trusts work here in Tennessee. But all that statutory authority is governed by our common law court jurisprudence, hundreds of years of trust operation.
Sure.
And just gets codified. But, common law is like how we do things, but it's not really, there's no statutory code.
Yeah.
So,
Okay.
but if you do stuff long enough, then and they eventually codify it and put it into, becomes part of our Tennessee code. And so there's a lot of that going on that governs how all that works. And that's a good explanation of the certificate of trust and what it's used for.
Okay.
And it's used for anything you deal with a financial institution. Like,
Yeah.
if you wanted to go to it even says in there, I tell people, when you go to the bank, that stuff I just told you about,
Sure.
prove to us you have a trust, they're not gonna go through all that. They'll just jump right to the chase and say, do you have a certificate of trust?
Yeah.
Because they won't go through all that. But in the certificate of trust, if the bank would say this, and banks, like I said, they know how things work. If the bank would say, okay, great, you want to change your bank account from you, the individual, into your trust, what do you want the new owner to be?
Yeah.
Who do you want? How do you want to title it? Well, right in that certificate of trust, on mine, it's item number 11. It says assets in this trust shall be titled as follows. And it'll be titled Stan and Tammy Pierchoski, trustees of the Pierchoski Living Trust, dated September 19th, 2019. Something like that.
Yeah.
And now, what that retitling is what puts it into the trust. You hear the word in the trust. You hear people talk about it. You talk about it. Lawyers talk about that where they say, the house is in the trust. My bank account is in the trust. There really is no such concept as in the trust. It's kind of street vernacular.
Sure.
Because the trust is a legal fiction. It can't hold property. It's not like we stack all your stuff up in the back of the building, right? And say, here's your trust and here's your stuff.
Yeah.
What in the trust means legally is you vest the property with the trustee.
Yeah.
Okay, so that's why if I have a bank account, Stan Pierchoski is an owner of it. If I want to put it in the trust, what I do is go to the bank, change the owner from Stan Pierchoski to maybe my daughter's name, Courtney, trustee of Stan Pierchoski's trust. Or me if I'm the trustee.
Right.
So when I change the title from me, the individual, to the trustee of my trust, I have vested the property with the trustee, and now it's in the trust.
Okay.
So I'd have my whiteboard, I'll draw a box and say, here's the trust. And outside the box, I'll draw a little picture of a house, right? And I'll draw an arrow into the box and then draw the house again in the box and say, that's the funding of the trust. To make that go from outside the box to inside the box, you need to retitle the ownership. And as soon as you do, entitle it to the trustee of your trust, it's in the box. That's what in the trust means. It's we say in the trust, but it's technically in the trust means vesting it with the trustee because it's a legal fiction. And now the trustee doesn't have any ownership. We're not giving it to the trustee. We're giving it to the trust. But the trust has to have a trustee, which is somebody who deals with the property in the trust, and that's the trustee. And so when you vest it with the trustee, they don't have any ownership. They just have the responsibility of dealing in it, and their responsibility is in the trust. It says what they can and cannot do with the property. So
you're just giving possession of property to the trust.
Well, he possesses it for you.
Yeah.
Yeah.
Interesting.
And but it goes to the trust. The owner of the property is the trust, and it's your trust. So have you really given it away? I mean, because it's your trust. If it's a revocable living trust, it's owned by your trust, but you have 100% access and 100% control. You can do whatever you want. You put it in, you take it out. You can give it to yourself. You can give it to somebody else. You have no restrictions whatsoever on access, and no restrictions whatsoever on control.
All right. Very, very good. We mentioned, some of this conversation is about avoiding probate to some degree.
Yeah.
Well, maybe somebody else has got a question. So.
Sure.
Hey, good morning. You're on with us.
I've mixed everything up to this point, so this may be not relevant. In fact, I've taken care of some business. I have a question for Mr. Pierchoski. I asked this question of the financial advisor the other day, and I would like to ask the same thing of him. Do you just handle when people come to you and tell you what they want and talk to them about trust, or do you do like professional advising, or do they mainly go to them first before they come to you? I just find sometimes the roles of CPA, professional advisors, financial, and attorneys, how they overlap or how they interact.
Okay.
I got to go back.
All right.
Yeah, that's,
Yeah, which comes first, the chicken or the egg?
well, we can answer that part. If somebody doesn't have a trust, they have property, right?
Yeah,
And what the property you're talking about when you're talking about financial advisors is money that resides in the posture of a financial institution, right? You know,
Yeah.
we talk about real estate. We're not investing in our real estate. You know, we're talking about your personal property, your pots, your pans, your tables,
Right.
your chairs, your cars, trucks and vehicles. But we're talking about money in the bank. And so, here's what I'll tell you what my role is. And I like to do what my wife calls stay in your lane. You know, if I'm out of my lane, I'm the first one to admit, hey, I may not be the best one to answer this question. And my lane is I will fund the trust, move property into it. But what I'll do is I'll do all your real estate. I'll do the deeds for that. That's in my lane. And I'll move your personal property and all your stuff. But I cannot move any of your bank accounts in. Okay, I'm going to use you for an example now.
Yeah.
Jeff Hood, I can't move, you got a bank account with, I don't know, Bank of Frank Ewing.
sure.
And I can't move that in for you because you have a contract with the bank and I am not a party.
Yeah.
So if I go in there and say, hey, Jeff's doing a trust with me, you know, he's paid my fee and we're doing this and I want to move this bank account in for him, the bank is going to say the same thing to me that they would to anybody. So under what authority are you going to move Jeff Hood's bank account into a trust?
Yeah.
And my answer is, I don't have an answer. I don't have any authority to do it.
Yeah.
I'm not the bank and I'm not you.
Yeah.
And those are the parties of your contract that you
Yeah.
have. So I can't do that for you. I tell people all the time, I'll put in the trust, everything I can put in for you. And that's the real estate and that's the personal property. Anything that resides with a bank, now when I talk about with a bank, it's not just a checking account or a savings account. Of course, those are included.
Yeah.
But it's investment accounts. It's CDs.
Yeah.
It's maybe Edward Jones or Raymond James managed accounts.
Yeah.
Or brokerage accounts.
Right.
All those are just money in the bank with somebody.
Yeah.
They have slightly different postures, but it's all money in the bank. All of them, I have no authority to put it in for you.
Yeah.
And so, but what I do is I say, I'll give you everything you need. You have to go in and put it in the trust, and I'll give you everything you need that the bank is going to want, which is that certificate of trust.
Right.
And I will even talk to, if for some reason the bank gives some pushback for some reason, maybe they don't understand it and they don't know what to do, and they call me and say, hey, I went to the bank and they said they couldn't do it, or they wanted to see the trust, or whatever. I'll be more than happy to get involved and talk to them, explain to them.
Sure.
And like I said, a couple of banks have invited me to talk to those people. I have helped train some what they call them CSMs, customer service manager type people at the
Yeah.
bank that deal with
Yeah.
them. And you know, I did First Farmers, helped them on some occasions back several years ago. And so I will give you what you need to put it in, but I tell people I cannot put it in for you. And now, from my standpoint, now I want to say, I might call you in 30 days or 60 days and say,
Right.
did you get around to putting those bank accounts into trust yet? And if it's like, well, you know, it's kind of busy, it's summertime, and I'll say, you know, if it's not in the trust, it's not in the trust, and it may have to go through probate at death if it's not in the trust.
Yeah.
Now, I'd put it in for you if I could, but I can't. Is there anything I can do to help you? In other words, do I need to come get you and drive you to the bank and hold your hand while we walk in and sit down? I will, I guess, if I have to. I don't want to do that, but I would put it in if I could, because then I know everything's in the trust.
Yeah.
But I cannot do that. Now, your financial advisor, I mean, you probably could do it with him, but if he's just an advisor, they just kind of tell you when to invest. But if it's the actual people that move the funds around, they could do it. Now, another thing that certificate of trust is good for is if you say, let's say you have a beneficiary-driven instrument, like an IRA, 401k, 459, a tax-deferred retirement account. Sometimes we call those qualified funds.
Right.
And so those have a beneficiary. So if you pass away and there's still some in there, you know, you can say where it goes.
Right.
So you might, but sometimes we might want to send it to the trust instead of to the people. Remember that child I said was a spendthrift?
Yeah.
If you just name them as a beneficiary, they're just going to cut him a check. Let's say you got $100,000 in your IRA at death, and your son, the spendthrift, is the beneficiary. They're going to cut him a check. Now, I had a lady one time call the company that holds the IRA and said, hey, my son's a terrible spendthrift. If you just cut him a check for $100,000, he's just going to blow it. And the response she got was, look, lady, we have an obligation to pay upon your death, and that's what we're going to do. I'm sorry about your child. I mean, but there's nothing we can do. We're just going to cut him a check.
Right.
Because that's our contract. The contract we have with you says at death, you named where everything goes, and that's what we do.
Right.
So not that they were being, jerks about it or anything,
They don't have a choice.
But they just explain it.
Right.
So how can you solve that problem? Well, easy. You go to them and say, I'd like to change the beneficiary of this IRA so that if I pass away, I want it to go to my trust.
Yeah.
Now you can do that, and that would be the same number 11 on the certificate of trust where it says, here, okay, who's the beneficiary you want to name? I want to name Courtney, trustee of the Stan Pierchoski Living Trust. And they'll put that in there. Now, my successor trustee makes the claim, money goes to the trust, and now in the trust I can put all kinds of terms and conditions on how the spendthrift kid gets his money.
Sure.
I can say, okay, here you can get it, but you don't get it all at once. You get 10% a year for 10 years, or you get a third at 25, a third at 30, and a third at 35. Or this all resides with your sister, and you have to justify to her the reason why you want some much money. And control the spendthrift problem.
Right.
But you can't control it if you make them the beneficiary, because they're just going to give the money. And so,
Very good.
and that works very well. Now, I typically, even if you don't have a problem to solve with the heirs, my scales tip ever so slightly in just naming the trusted beneficiary anyway, for a couple of reasons. One, if something like that develops, right, you say, I got 3 kids, none of them have a drug problem. Well, I don't know, 20 years from now, that's possible, right?
Yeah.
It's easy to change the trust and put these controls in. Okay?
Sure.
And second of all, let's say you have 3 kids, and you name them as 1/3 beneficiaries on your, whatever the account is. All 3 of them have to make a claim and jump through all the identity hoops. And when you make a claim on something like that, it's not super complicated, but it can take a while because the insurance company asks for this, they ask for that, and then you send it, and they come back and say, yeah, but we need this too, and eventually they'll pay, right? Well, each one of them has to do that for their third. If it goes to the trust, just your successor trustee is the only one that has to do it.
Right.
And that's a little bit of an advantage too. But if you ever want to control how it goes to them, all you do is modify the trust, and that's easy to modify. So,
Very good.
I think that answered your question.
Yeah, I think so. I think so.
But the advisors can get involved, and to be honest with you, there's something, one point that I wanted to bring up with financial advisors, and don't always mean this the way it sounds, but sometimes they don't quite understand what we do. Like our asset protection trust. We know it, getting down to the end here, I think I worked this in. The asset protection trust is an irrevocable trust. Okay, now that is a buzzword to financial advisors, and they think it means, okay, here's what they think it means. Okay, if it's an irrevocable trust, then you have to get an EIN for that trust. Okay, and if it's an irrevocable trust, then you're going to be taxed at the much higher trust rate. Okay.
Okay.
And that's what they tell the people. They scare the people to come back and say, you know what, I think I'm changing my mind on the asset protection trust. I'll say, why? And they'll say to my investor, no, not all of them. Every now and then it happens. I've got a series of letters that I have sent and given these folks, and it's just like a mini research to explain to them what we're doing.
Sure.
And I actually highlight in the revenue rulings what we're doing and where it applies. And what we're talking about is the trust. A trust can be either a grantor trust or it can be a non-grantor trust. Those phrases don't mean anything to the average person, but if it's a grantor trust, which is what we do, so our asset protection trust, our grantor trust, so our revocable living trust. And basically what that means is this. It's kind of it's a grantor trust, and we have language in the trust that says that property in here is estate inclusive.
Yes.
Okay. Now, what that means is all the properties in your estate at death.
Yes.
And non-grantor trust is what the IRS refers to as tax neutral. So let's just say, we'll use real estate for example. You have a house, you're renting a room. You're getting $500 a month. Okay. You have rental income, right?
Yep.
Now, if you don't have a trust, you just have a house. And so every year you have to report on your personal 1040 form that you got this rental income.
Yeah.
Then if there's tax on it, calculate the tax and you have to pay the tax. Income tax.
Right.
If you now say, you know what, I want a trust, and I move this house into the trust, and I still got the renter.
Yeah.
You still got this renter. Now it's making $500 a month income, but the house that's making the income is now in the trust.
Yes.
And that confuses them. Now, the IRS is, if you do certain language in there, like this estate inclusive language,
Sure.
they say this is a grantor trust. And what the IRS is saying when they say it's tax neutral, they say if the trust makes income,
Yeah.
that is the grantor's income.
Yeah.
The grantor is the maker of the trust, right?
Right.
I call it trustor, but it's same thing.
Right.
And they say it's the grantor's income. So what it means is, the same scenario, the guy files his 1040 form, now he puts it in the trust, he still takes that income and files it on his personal 1040 form and reports it as his income, because that's what it means. Tax neutral to the IRS means you don't get a benefit and you don't get a deficit for the property earning income in the trust or out of the trust. They say it's your income. We want it reported. We want the tax paid on. Doesn't matter if it's in the trust or not in the trust for us. Okay. So it doesn't need an EIN of its own. We use one of the Social Security numbers of a couple to identify the trust, and then if it doesn't have to file its own tax return. You know, a tax return for a trust is a 1041, and you don't have to file that for a trust. You file it, any income it makes, you put on your own tax return because it's considered your income because it's a grantor trust. Now there's a non-grantor trust. You know, I bring this up because at the seminar somebody brought that up. They wanted me to talk about a non-grantor trust. Now that has language in it that's called estate exclusion, meaning at your death, this property is not in your estate.
Okay.
So what you're doing is you're completely. One thing when we have the grantor trust is we maintain control over the property.
Okay.
But when you have a non-grantor trust, you are so divorcing yourself from ownership. You don't have any ownership, you don't have any control, and you have divested yourself of all ownership.
Yeah.
Okay. Now it's in the trust. Any income it makes, the trust has to report the tax.
Yeah.
And and that is of course at a higher percentage when that happens.
Okay.
And it has lower rates to where it kicks in. So and at your death, that property is not in your estate. It's estate exclusive. I do not do non-grantor trust. I mean, they have a purpose in business planning and some high wealth planning and stuff, but I don't even do them. All the trusts I do are grantor trusts with estate inclusion, because that's what we want to accomplish what 99 or 100% of people will do. Not sure how I got off on that, but
Yeah. Well, a quick touch on something that just crossed my mind when we were talking earlier about avoiding probate.
okay.
And we've said this before, you know, doing nothing is a plan, but it ain't a good plan, right?
That's right.
But if you find yourself in that circumstance, and you've done nothing, you have no trust, you have no will, and you pass, it ends up going to probate.
That's right.
So kind of explain that process, just a quick.
First of all, I'm going to say, you know, I can think of a time when doing nothing would be probably a good decision.
Yeah.
You got a homeless guy in downtown Los Angeles, has nothing,
Yeah.
don't own anything,
Yeah.
passes away. I mean, doing something like a plan, probably he's going to end up with a result. Anyway.
Well, there's nothing to plan for.
Well, that's right, but in the result's going to be the same. But that's not us.
Right.
I'm not dealing with that. But the question was, if you don't have a will, what happens?
Yeah. If you don't have a will, you don't have a plan, then what happens?
Unfortunately, the state of Tennessee writes one for you.
Yeah.
God bless them.
They know what to do.
And it's already been written. They already know who your heirs are and what their percentage is. It's called the laws of intestate succession.
Yeah.
And if you haven't done it, because if you pass away and don't have anything, you have stuff.
Yeah.
And this stuff has to go somewhere.
Yeah.
So the way they bring it into the probate court and say, well, you pay. What triggers the probate code is you passed away with what you own titled in your name.
Yeah.
That triggers our probate code. If you pass away entitled to the trustee of your trust, that triggers the trust code for descent and distribution. So they say, do you have a will? No, we don't have one. So you go. They open up an estate, and now you have you have an administrator. When you have a will, the will needs to be executed, so you have an executor.
Right.
You don't have a will, you have an administration, so you need an administrator in the same role.
Right.
So everything's the same. You're in probate, everything's the same. It's just that the big difference between the two is if you have a will, you have some say on where it goes. If you don't have a will, they're going to follow the laws of intestate succession.
Yeah.
And they're going to look to see if you have a surviving spouse. And if you do, she's going to get a third or up to a child share under the statute. And then they look to see if you have any natural blood children. If you do, they're going to divide the other 2/3 essentially.
Right.
And which is not what most people want. Most people who have wills have a reciprocal will that says, if I pass away first, it all goes to my wife.
Yeah.
And if she predeceases me, then it goes to my 3 children.
Yeah.
And the wife says the same thing. Now,
Yeah.
if you're the first death, it's not going to your spouse. If you don't have a will, if you don't have anything, it's not going. A third is going to your spouse. The other 2/3 are divided by your children.
Yeah.
Now, if you don't have any children, it's all going to go to the spouse.
Yeah.
If you have one child, half is gonna go to the spouse, because I said, the surviving spouse gets a third, or up to a child share. The only time it ever gets up to a child share is when you only have one child.
Right.
And after children after that, they split the 2/3.
Yeah.
And so, but that may not be what you want. You may not want some of it to go to the kids. You may want to leave it with your surviving
Right,
spouse. So,
right.
you know, if that's what you want, then maybe do it.
So
not
it's
doing
much,
it.
much better to plan.
And if that's what you want, then maybe not do it. You might get what you want when you're not doing anything.
Well, we're down to a minute, so I won't tell
Oh.
folks how to get to you.
Sure. Pierchoski State Law, Pierchoski Elder Law, 931-363-7222. Or you go to my website, estateplanstand.com.
Yep.
And you can call me or email me from there. Ask a question, I'm more than happy to answer it. Next seminar coming up, it's all the way out to the end of July 25th. That's a Saturday. We do it at 10 o'clock. We call it Wills, Trust in the Nursing Home. That'll be right here in the back of the building of WLX radio station. I'll talk about that more as we get closer.
That's right. Stan Pierchoski, everybody. Pierchoski Estate Law in Pulaski, Tennessee, just off the square over there in a newer office.
Yep. Actually hired a new person.
Yeah.
Just started Monday.
And a new grandbaby.
And a new grandbaby.
Things are going well for Stan.
Yeah.
All right. I'll see you next time, buddy.
Always a pleasure.
Thank you.
I think it leaks so bad about the glove.